Good morning, Ms. Hussein.
Good morning.
Did I pronounce your name correctly?
Indeed so, thank you.
All right. Are you a South African citizen?
I am, yes.
Okay. Well, you have not provided a copy of your ID document. Is that identity number in your matric certificate your ID number?
Yes, it is.
What number is that? Because it's not particularly legible.
It's the year 85.
Sorry?
8509.
Or is that 5, not 6?
Yes, no, 85.
85091 300
That's correct.
86087. Okay. What academic qualifications do you have?
Briefly, I did my matric and then obtained an LLB from the University of Witwatersrand. I thereafter undertook a practical legal training course. It was a certificate course. Thereafter, there was a notarial practice course, which was also a certificate course. I practiced for an attorney for about 7 years, post-articles. I then joined the Johannesburg bar in 2015 when I did my pupillage at the Johannesburg bar. Thereafter, in 2019, I did a certificate course in mediation, in dispute resolution, with the focus in mediation. And I am currently undertaking I would say it's a course, it's an online course. It's a course that's divided into an online part and a physical part, in terms of which I've been appointed as a judge and evaluator for the Hague.
I'm sorry, just the person coming in just disturbed me for a while. Just repeat that last bit. You have just been appointed as what?
I've been appointed as an evaluator and a judge for a moot court competition at the Hague, based in the Netherlands, for the ICC, the International Criminal Court. So that is, it's two components. It's the physical component, which will take part in June, and there is an online component, which I've just finished now.
What exactly will your role be there?
It's the role of an evaluator and a judge. So in terms of the online part, that's for the evaluation of written memorials, as we commonly refer to them here in South Africa as heads of argument and submissions. And with respect to the physical attendance, which will be later during this year, those will be physical hearings at The Hague itself.
Mm-hmm. But you are yet to start with that undertaking?
Yes, with that part.
Okay.
I've just completed the online part.
All right. Your CV does not state which firm of attorneys you were attached to.
Initially, I started off my articles at a firm called Batulis Krause Incorporated. I was just there for a short period of time because they mainly focused on family and matrimonial matters, which was not a field that I was that I wanted much experience in. So I ceded my articles to a firm called Tribunal Incorporated. They were based in Sandton. They were a boutique commercial law firm, and I stayed there for the duration of my articles, which was the balance of 1.5 years. I then became an associate, and I was then promoted to a senior associate up until, I think, 2014.
All right. And you say it was a commercial law practice?
It was a commercial law firm, so
all right.
It was litigation experience, it was dispute resolution experience.
Okay. So you've been at the bar since 2015?
2015, indeed.
All right. What kind of work do you do?
When I did my pupillage in 2015, I gained experience in the fields of competition and intellectual property law. Those were very exciting fields that I chose to be mentored in. Unfortunately, I haven't been able to break those barriers at the bar in terms of receiving those briefs. However, I retained, once I was admitted, I retained my commercial background practice. So till today, I do mostly corporate commercial matters. There's a large focus of dispute resolution. But if I needed to list the fields of experience, of the fields of law that I've gained experience in, then they range from your construction administration, insolvencies, your general corporate commercial. The list goes on. I'm not sure if you'd like me to continue.
Yeah. No, that's enough. Do you have any experience of adjudicating disputed claims?
Disputed claims?
Yeah. Have you worked with an administrative tribunal, for example?
I haven't worked per se in an administrative tribunal, but I have been accredited as a mediator, and I do sit in mediations in the role as a mediator. More so in terms of in private disputes, I have chaired labor-related disputes. So I am familiar with the processes of what the role of the chairperson would entail.
Have you written any rulings?
None that I can provide the commission with, because they were all private disputes.
So they were?
None that I can provide the commission with, because they were all private disputes. But there were rulings that were made, indeed.
Do you have any experience with the water law?
Besides the research that I've undertaken in preparation of today, unfortunately not. I have, the brief experience that I have comes from matters such as construction and mining, in terms of which licenses are, there's a request for a license to be approved, or there's a dispute as to whether there's a dispute relating to the granting of the license. So I'm familiar with water law in that respect, I would say, but not, I haven't done a course in water law, if that's...
You've not done a case involving the water law?
Well, not per se. They've been ancillary matters, like I said, from other fields of law.
Yeah.
But in my preparation for today, I have looked at many of the rulings. I have familiarized myself with the legislation, with...
So you would have read up on the National Water Act?
I have.
Okay. What would you say is the purpose of this tribunal you want to head? And what are its functions?
Okay, so in terms of its purpose, my understanding is that the National Water Act itself has been promulgated to protect the water resources of the country. So with regard to Section 2 or Section 3 or the preamble itself, the objective itself is to protect that scarce resource. And my understanding is that the tribunal has been established to, perhaps if I can put it in a nutshell, as a court of first instance for water-related disputes, in terms of which there is speedy and effective resolution with regard to any water dispute. With regard to, I think, the functions of the tribunal itself, my understanding is that appeals are lodged to the tribunal, and those are with regard to the use of water use entitlements. Also appeals with regard to, to prevent or to remedy a wrongdoing, or to prevent any pollution of water resources, and if necessary, I think the third leg was...
Sorry, may I ask, do you have notes in front of you?
No, I have my CV, etc. But I think I'm becoming a bit more flustered when I see the camera in my face. So that's when I tend to look down.
No,
I
just
apologize
ignore
for
her.
that.
You just ignore the cameras.
I will try my
Don't
best.
pretend she's not them.
I apologize.
What do you understand the role of the chairperson of this tribunal to be?
So from what I understand is that once an appeal is lodged with the tribunal, the record is collated and a case file is prepared. And what I understand is that that case file is sent to the chairperson of the tribunal. The chairperson then makes a decision as to which members of the tribunal will make up a panel to adjudicate the dispute or the case itself. And that panel could consist of members of between 1 or 3 members. The chairperson itself could also be a member of that panel. So in terms of there are administrative functions for the chairperson in terms of allocating files. I've seen that there are reports that are written to the minister, and I would think also just your usual support in terms of the functioning and the management of the tribunal itself. Those would be the duties that the chairperson would be tasked with.
All right, thank you. I'll hand over to the rest of the commissioners now.
Thank you.
Do you have any questions for the candidate? Commissioner Pillay?
Thank you, Chief Justice. Good morning, Ms. Hussain.
Morning.
Can I ask, have you done any investigation into what are the current challenges facing the tribunal?
I have. So one of the key issues that I've come across is the timeframes between when appeals are lodged and a decision is made. And I see that is quite an issue with regard, because it's a significant delay in the matters being adjudicated on. So I think that is one of the key issues that the tribunal is currently facing.
Okay, and do you know why that's the case? Why is there this enormous delay in the finalization of appeals?
From what I understand, and obviously this is going to be a very basic view of someone sitting at the outset, sitting outside and making a judgment call, is that there are delays with regard to from the department side in having matters allocated, or just the delays in having the record collated. So I think those are perhaps maybe some of the delays that, some of the reasons that cause delays.
Thank you, Chief Justice.
Yes, Deputy Minister.
Thanks. Good morning, Advocate Hussain.
Good morning.
Just a few questions. Your ICC matter, what is the issue there?
It's a matter which it relates to economicide. So in a nutshell, there is agricultural land which unfortunately has been harmed to some extent, and this is to the benefit of some people and to the disadvantage of others. So it's an economicide matter.
So is this ICC or ICJ?
ICC. It's
International Criminal Court?
Yes, it's a moot court competition.
Okay. A moot court arbitration?
Indeed. Competition. Correct.
Competition, oh, okay. So it's not actually the ICC itself?
No, unfortunately not. I'm hoping this would be a step up.
Okay. Then I just wanted to ask you, you have a problem with cameras. You indicated that now, or we saw that now when you said you were having problems. we had a request yesterday that this interview not be televised. How are you going to handle, I mean, the Water Tribunal could be dealing with a very high-profile public interest case of which there's a lot of media attention, and that includes photographing cameras and video cameras. How are you going to handle that?
I think in the same way today. I think what's important is that I show up and I present to my best ability. If I'm not comfortable with the camera, that's on me, and I just have to deal with it, but that can in no way hinder or impede on, for example, if there is a matter which is of a high profile. I mean, it's my issue, I need to deal with it, and I just need to be comfortable around cameras. So just try to ignore it as best as I can, and I mean, that should in no way hinder the work that I need to do.
Then just the last question is that you don't have water law experience. What experience have you got on adjudication on socioeconomic rights, other socioeconomic rights as opposed to just water?
Admittedly, not very much. There was a human rights course which I did a few years ago. I am deeply, very interested in constitutional law, in administrative law. Unfortunately, my practice, I think there's just been one or two matters that we have had the opportunity of appearing before the Constitutional Court. But unfortunately, my practice hasn't developed into that sphere as much. So I'm not going to be able to show on my CV that experience that you're looking for. But having said that, having conceded that, I will admit that the socioeconomic rights, I beg your pardon, are very important to me, and that's why I put my name forward for this position. I view water as a scarce resource which needs to be protected. I am aware of the fact that there is a majority of the population of the country which doesn't have access to clean water or even water itself, which is in my view, a fundamental human right, which again is protected by the Constitution, but unfortunately, if you look at the reality is that people just don't have access to that. So that's something I'm deeply concerned with. And in my small way, if I am hopefully appointed to this position, I would like to make a big difference I'd like to make, but whatever difference it is, hopefully, so the socioeconomic rights of the people of this country are perhaps less infringed upon.
I said it was the last question. This one really is the last, but just to follow up from that. So we've got no indication of seeing what your actual views are in terms of, well, there are no judgments, there are no documents, but one would like to see what your views are on socioeconomic rights, because obviously there's a broad spectrum of views politically, not party politically, obviously, but we've got nothing that you can show us that you wrote this article, you spoke somewhere, anything like that.
Unfortunately not.
Okay, thank you.
Thank you, Deputy Minister. Commissioner Matolo Lebu.
Thank you, Deputy Chief Justice, and good morning, Advocate Hussein.
Good morning.
You know, my interest in your CV, you as the Deputy Minister says, indicated that in water law you deal a lot with socio-economic rights. I saw that you did mediation, and I didn't quite get a sense of what type of mediation matters you're doing, and can you just elaborate on that?
Okay. So in 2019, I undertook a certificate course with the Arbitration Foundation of South Africa. So I was accredited as a mediator in accordance with AFSA's rules. Since then, I've sat as a mediator in commercial law disputes. There's been a sports law dispute. There has been a a few disputes with regard to employment law, but not with regard to socioeconomic rights.
Any community mediation?
I beg your pardon?
Any community mediation?
Mediation.
Yeah.
Unfortunately not. It's something I'd like to be involved in, but unfortunately not.
Thank you, Deputy Chief Justice.
Prof?
Thank you very much, DCJ. Good morning, Ms. Wilson.
Morning.
I just want to ask, can you just outline to us the procedure that is, or that should be followed when there is a decision that has been taken in relation to water use and an application is made to the tribunal? How is either the application or the appeal, how is it made? And what is the procedure that is followed up until the matter is adjudicated?
So just to clarify, this is with regards to an appeal?
Yeah, let's restrict ourselves to an appeal.
Okay. So I think from what I've picked up from in my research is that once a matter is, whether it's an appeal on the water use entitlement or the granting or the refusal of a license itself, a case file is opened that would constitute the record of the court of first instance. Those hopefully would have all the requisite documents with regard to the case itself. And that file is then passed on to the members of the panel that will sit in, hopefully firstly analyze the dispute or whether it's facts disputes with regard to issues of law or facts. I would think then thereafter there'd be an analysis of the issues at hand. You'd have to interpret the statutes, the applicable statutes, and then hopefully make a ruling that's reasonable, fair, just, and equitable with regard to the circumstances. And I believe that written rulings are always issued, so I would assume that the last step would be to prepare the written ruling.
Thank you very much, DCJ.
Yes, thank you, Deputy Chief Justice. I just have 3 short questions for you, Ms. Hussein. One is, last year we interviewed for this position, we kept it open. One of the presentations we got was from the then Chairperson, Advocate Mark. He gave us a diagnostic report. Have you read it?
Unfortunately not, I haven't seen it.
So you don't know that there is currently a backlog of 5 years at the Water Tribunal?
I do know that there is a backlog, and the reason I know that is because for my preparation for this interview, I watched that interview last year where you asked those questions and you gave a few instances of matters where there have been a backlog of about 5 to 6 years. Yes. So I am aware of the backlog, but I unfortunately have not been privy to the diagnostic report.
And then, because it seems to me if I was trying to get this job, and I was aware, fortunately, as you say, because I've watched the interview, you would be aware of the diagnostic report and you would have bothered to lay your hands on it.
Unfortunately, I wasn't able to get to obtain it.
When you say you were not able, did you try to get it?
I did. I did a search in the web, but unfortunately, I wasn't able to find it. It could be there, but it's just perhaps for some reason I didn't get a hold of it.
Yes, but you could have just sent an email and asked for it.
I concede that.
Now, the second question I want to ask you is, when I look at your CV, you attached 3 letters of recommendation, and so I was trying to see what people say about you, but then I realized that the first one is from Fergus Blackie, but it's 31 October 2013. The second one is from Peter van Black, who's a member of our bar, but it's also 25th August 2014. And the last one is from Chwene Incorporated, which is on the 13th of February 2012. So none of those actually tell us anything about your ability to take this role. In fact, one of them was about you applying for pupillage.
That is correct. Those letters were prepared in pursuance of me applying for pupillage. I haven't obtained, perhaps it was a shortcoming on my side, that I haven't obtained anything more current, but those were letters that were prepared for pupillage.
Then the last thing is the most recent judgment of the Constitutional Court relating to water is
Yes.
the Lotter case. What was that case about, and what did the Constitutional Court say?
It was a unanimous decision by the Constitutional Court in terms of which the right in terms of Section 25 to transfer water use entitlements to third parties was permitted, firstly, and the second leg was that that compensation in terms of that transfer would also be permitted. Those findings were in terms of the Act itself.
What did the judge say, Judge Madlanga?
In a nutshell, I would say that the transfer of the license was permitted to third parties. But there was also, towards the end of the judgment, I think it was part of the analysis to an epilogue, which
I think that's fine. The first part is fine. The other two, we can figure that out later. Thank you. All right.
thank you.
Good morning, Advocate Hussein.
Morning.
You know there's a backlog of cases in the Water Tribunal. And I would imagine you agree with me that as the chairperson of the Water Tribunal, you need to have some administrative competence to run the tribunal. Am I correct?
Indeed.
Can you tell us what you would do to tackle this backlog?
Like I said previously, without tainting the tribunal in any negative light, because I completely acknowledge that I'm sitting on the outside and I am just making a judgment call from the outside. I would think that perhaps there should be perhaps the solution lies in a administrative / support function where there just needs to be, and I say this, I feel bad actually saying this, but there just needs to be better administration at the helm of the tribunal.
Well, I think that's a bit of a generalized statement. These are cases that require attention. So what I would like to hear you tell us is, have you got any views about how you would ensure that cases that come in are treated in such a way that they get to a hearing-ready status as soon as possible, and that the determinations coming out of there come out expeditiously? That's what I want to hear you talk about.
Okay, so I think there could be a two-tier approach to this. One, in terms of which there are new matters, which, for example, an appeal is lodged, say perhaps 10 days ago, and that's a fresh matter, and the contrary to that would be one of the matters where there are backlogs. So I think there have to be systems in place where there is a distinction between those two matters. So obviously a fresh matter needs to be, from the date of the appeal to the date that the ruling is made, that needs to be done within the requisite time period. But with regard to the other matters where there is a backlog, I think that there needs to be an acknowledgement that there are those matters and that they need to be given priority. So perhaps in establishing different committees that could deal with each of those, whether it's a fresh matter, one of the matters that stem from a backlog. So you have different committees dealing with it, looking at what the issues are, and trying to, in terms of an administrative capacity, to just get the matter ready for adjudication and for rulings. That would, in my view, that would give you cost-effective remedies.
Thank you. Thank you, DCJ.
Thank you, JP. Do we have questions from the virtual platform?
Yes, we do, DCJ.
Yes, go ahead, please.
Thank you, DCJ. Morning, Advocate Goosen. My question is just one of the practical workings functioning of the court. So if the chairperson of the Water Tribunal wants a witness to take the oath or, make an affirmation that the evidence they give will be the truth, nothing but the truth, and the witness refuses to do that, despite the chairperson insisting that they do that, what should the chairperson then do practically so that the court can proceed?
Sorry, I'm not so sure if I've understood your question. Sorry.
A witness before the court doesn't want to be sworn in or do the affirmation that they're telling the truth. What practice should the chairperson of the court do?
I don't think a witness can be forced to testify. However, there would be a valid subpoena which would have brought the witness to the hearing itself. So if the issue is just with regard to the affirmation or the attestation, I would perhaps, I would try to perhaps just get some kind of an inclination that the witness would actually assist the tribunal or the tribunal in its hearing. Just some kind of, sorry, I see you need to say, you're trying to say something.
No, thank you. I see you struggling with that. It's fine. Can we perhaps move on to another question?
Sure.
And then, the Water Tribunal, obviously there are various disciplines that can provide a positive impact on the Water Tribunal. So just as a general question, what would you regard as the ideal team to hear a dispute before the Water Tribunal?
Sorry, an ideal team?
Yeah, so what should the various persons sitting on the tribunal, what should be their disciplines to have an ideal team?
So what I've seen is that the members of tribunal itself are made up of people with, it has to be a specialized skill set. So whether it's in terms of law, engineering, office support, the role of a COO, you'd have to have all of those structures in place for the adequate functioning of the tribunal itself.
Thank you. And then my last question is, part of your functions as a chairperson would be to provide input and do the rules of the court. Have you had a look at the rules and what would you suggest should change in that regard, or how could they be improved?
Without opening up a bit of an issue, I think one of the issues that stuck out for me, for example, was the whole issue surrounding the so-called privatization of water use, in terms of which the Act was, I think it was in 1998 when the Act was publicized. The department itself went out and said that you can actually trade the water use entitlements, and that continued. It was permitted up until, I think, January in 2018. I might have my date wrong there, when a circular by the department was issued saying that Section 25 does not permit water use, the transfer of water use entitlements. So for me, that pointed towards an issue with the Act itself, with the rules itself, and that obviously subsequently with the three High Court decisions, the SCA decision and the Constitutional Court decision, what we learned from that whole process was, although the Act, or the preamble of the Act, Section 2 and Section 3, although the purpose of the Act is to protect the water resources, there is also a disparity which needs to be addressed, and those are issues, I think, that the tribunal itself and the chairperson itself, you'd have to look at those rules and just bring it more, just align it more with today in the world, so the socioeconomic issues that we face today and the world that, not the world, sorry, the issues that the countries face today. So you'd have to look at the Act and you'd have to look at the issues, resolve those disputes as best as you can with regard to the applicable legislation in front of you. And if not, hopefully approach to the legislature for some reformative changes.
Thank you very much. Thank you, DCJ.
Thank you, Commissioner Panat. Any further questions from the virtual platform? AP Person.
Thank you, DCJ. Good morning, Advocate Hussein.
Good morning.
Just for my benefit, I just want to find out, what did you seek to achieve when you included the documents, that is letters, one from Messrs. Chwen Incorporated dated 13 Feb 2012, and the one from Arbitrator Blakey, 31 October 2013, and lastly from Mr. Van Black, 25 August 2014, when you compiled your documentation in December 2022.
Well, I understand that when I submitted these documents, I did need character references, and I did need references from members of the legal profession. At that point, these were the letters that I had in my possession, and that's why these letters were included. And like I said before, perhaps it was a shortcoming on my side that I should have included more up-to-date references that would speak about my capabilities and my experience. But having said that, those are the letters that are before the Commission today.
And I take it that you do accept that those letters say nothing about your competence for the position to which you now aspire, that is Chairperson of the Water Tribunal.
It could be viewed in that way, yes.
Thank you.
Thank you.
Thank you, DCJ.
Thank you, AP. Commissioner Baloyi.
Thank you, DCJ. Good morning, Mrs. Sin.
Morning.
Yes, going by your CV, you don't have any adjudicative experience at all.
So, like I said, I've sat as a mediator. I've sat as a chairperson in disciplinary inquiries. Yes, I don't have rulings that were made in terms of the tribunal, correct? It's not experience that I have, but it is, of course, experience that I would want to gain, and that's why I put my name forward for this position.
Yes. When you say in court, you mean appearing in court. You've not had to sit and determine a matter in court.
Indeed, yes. my appearances have been as counsel.
Yes. And also the experience about leadership, setting up systems, being in charge of an organization, setting up systems, procedures, and policies. You don't have such experience, at least according to your CV. I don't see anything in your CV.
Perhaps what I could draw a little bit of attention to is when, I think it was in once I joined the group that I'm currently with, I became a member of the pupillage committee, and I think I served in that committee up until 2017 to 2020. The purpose of that committee was to mentor young or junior professionals doing pupillage. So I think we saw an intake of about, during my time with the committee, you'd have pupils come in, we'd set up lectures, we'd have some kind of a support group, there'd be exercises that they would do with regards to their pupillage and just in preparation for the exams and to be admitted as counsel.
But that doesn't involve setting up systems, procedures, and policies as head of an institution.
No.
Right.
Unfortunately, I don't. I do concede I don't have that experience, but it is, again, experience that I am willing to.
All right. And lastly, you, as you're sitting there, if you were appointed to this position, you would be walking in blind. You have no idea what this entity looks like right now and what you would need to do. Is that a fair comment?
Absolutely. I am the person on the outside. Okay. I don't know the intricate dealings of the tribunal itself. Hopefully, if I am appointed, I would obviously take the time to get to know the way the tribunal functions on a ground level, and that is something that definitely I would have to do.
Thank you, Mrs. Sen. Thank you, DCJ.
Thank you, Commissioner Baroy. Ms. Hussein, this brings us to the end of your interview. Thank you very much for making yourself available for this vacancy. Unless there's anything you want to say to us, you are free to go.
Perhaps if I could just take a minute. I do concede that I don't have perhaps the experience that, when I say experience in water law, that perhaps the members of the Commission are seeking from the candidate. But my answer to that is I am here, I am willing, I am ready for the challenge. It's a challenge that I am willing to take up, and I will, if the appointment is made, I will do my best to fulfill that role and to fulfill the purpose of the Act itself. In conclusion, thank you to the members, to the Commission, for giving me this opportunity to be interviewed today. Thank you very much.
You're excused.
Thank you.
Good morning, Advocate Lucelo.
Good morning, DCJ.
Is that how your surname is pronounced?
Yes, that is correct.
Okay. I
DCJ.
always worry about mangling people's names. I'm very fussy
Sorry,
about
Deputy
mine.
Chief Justice, there's no sound.
You
on
can't
mine.
hear us?
Yes, thank you, now it's come through.
Oh, all right. You are a South African citizen, I believe.
That is correct, DCJ.
You are a holder of 3 legal qualifications, a BUris degree, an LLB degree, and an LLM in international law.
It is so, DCJ.
And I noticed that one of the subjects you did for your master's degree is international environmental law.
That is correct.
Can you just tell us briefly about your work experience? What have you done that would qualify you for this job you seek?
Okay, firstly, I must say I am largely a career public servant. For a long time of my work life, I was a public servant. I worked in the South African Air Force as a legal advisor, but it was in the military part, so I was a soldier. By the time I left, okay, the work that I did there are military courts. You can either be assigned a function of being a military prosecutor, alternatively could be a military defense counsel, military judge, or a military review counsel. So what I did was, because they were rotating us, I was once a military prosecutor, senior military prosecutor, and also I was a senior military defense counsel. I was a review counsel, and the last assignment was the registrar of the Court of Military Appeals. But in addition to that, we're giving general legal advice on a vast areas of law. And the part of work that I did also was when I was involved in a task team that drafted the supplementary measures discipline bill. But when I left, it had not been finalized. Then in 2006, I left the Department of Defense and I went to work for the Department of Science and Technology. There also I did mainly, it was legal advice, legal opinion, legislative drafting. There was very little litigation. In fact, I think that's why I got my baptism in legislative drafting. I was involved in a number of legislation that I drafted, but I think the most important one there was the Geographic Advantage Area Bill. It's now an act, and we started that bill from zero. That legislation was drafted in support of South Africa's bid to host the square kilometer array. And it was quite involving because there were provisions of that legislation which required that certain activities, both in terms of the sound, there should be no sound and dust pollution in the Northern Cape for the purposes of setting up the different telescopes. So, but that requirement meant a number of public entities and even private companies would have difficulty in implementing their license conditions. For example, it was Transnet, it was SABC, you would have the South African Airways, the Vodacom and the likes, because the requirement was that the core area, which was the center of the whole area where the square kilometer array was to be hosted, should have no sound and dust pollution. And in fact, it would also affect mining. So if there's no sound pollution, it also means also the radio signals were not to be allowed in the core area. So that's why I'm saying, that's why I got my baptism, because we have had to, it was only myself and my former colleague in the department who have had to sit and face members of the public and also the industry to present the bill and what it seeks to achieve and how we are going to address the challenges which arose from those the provisions of the bill. You will also note that I also drafted several legislation. It was the Space Agency. It was meant to establish the Space Agency and also the Technology Innovation Agency. When I think some of them, I can't recall, but some of them I went as far as Parliament. But the square kilometer array, I can tell you, that one I went to Parliament and we finalized it. When I then left to go and join the National Department of Social Development in 2007, I did almost the same job, save for the fact that it was at a higher level. I was then a chief director. And I was doing also legislative drafting, legal opinion, litigation, and contracts management. There, when I arrived, the National Water Act, not National Water Act, the Children's Act was to be implemented, was already in the process of being implemented, but we required regulations. So the department had appointed a consultant to draft the regulations, but I took it over and started almost all over and made sure that it is compliant. You will see that set of regulation is very thick. I also was involved in the drafting of the amendment to the Social Assistance Act. I drafted the regulations for the implementation of the Social Assistance Act, and also in particular there were regulations relating to the appeals, where members of the public who would have applied for a grant to the SASSA, what we call South African Social Security Agency, if they were aggrieved by the decision, they would have to appeal to what is called the Independent Tribunal for Social Assistance. So I drafted those regulations, and I know I have not indicated that part in my CV, but for about 3 years while I was at Social Development, I was the Acting Deputy Director General responsible for the Independent Tribunal for Social Assistance, while at the same time I was also substantively Chief Director at Legal Services. So,
what kind of work did you do for that tribunal?
Well, I was responsible for supervising the appeals structure, where all the appeals which have to be dealt with from SASSA, where people appeal against the decision of SASSA if they were aggrieved. I supervised the social assistance, the Independent Tribunal for Social Assistance, but what we did also, we appointed practicing attorneys and advocates to adjudicate those appeals. I didn't do the appeals myself, but we provided training. I drafted the regulations also for the Independent Tribunal. And then I was also involved in litigation, but although there was litigation, it was not to the extent to which I then encountered when I moved to the Department of Water and Sanitation in 2013.
Yeah.
I took a lateral transfer in 2013 at the instance of the then Minister of Water and Sanitation at Namolewa, because she was previously with Water and Sanitation, but she was then reshuffled to, she was with Social Development, and then she was reshuffled to Water and Sanitation. Then I took a lateral transfer. I was a Chief Director, Legal Services then. I think that was the most difficult department I've ever worked for, but from which I also learned a lot. In that department, I was doing the same as I have indicated previously, save for the fact that when I arrived, there was an intention to merge the National Water Act with the Water Services Act. But at that stage, also there was a draft bill, but it was of no help. And I started all over to merge the two pieces of legislation, but also to address the challenges that we encountered with the current National Water Act. When I left the department, we had already gone to the office of the Chief State Law Advisor, who had certified the bill to be constitutionally compliant. But as it would happen, generally when there are changes in the political principles, they will start all over again. But that bill I drafted myself. I did not outsource it. I also used, my colleagues who were working under me to develop that bill. And it addresses some of the issues that even currently, it sought to address them, that we currently encounter. And I suspect I will have to come to that point later, which deals with matters relating to the implementation challenges of the National Water Act. And part of those would relate to the water trading. There's also a vexing aspect that relates to what is called the existing lawful water use and the verification process of a claim for an existing lawful water use. But at that stage, when I was still the Chief Director of Legal Services, I worked closely with the then Chairperson of the Water Tribunal. She's now a judge. But for some period of time while I was there, this Water Tribunal was dysfunctional because the minister had not appointed the chairperson and the members of the Water Tribunal, because there was a thinking at that stage, although it was just before my time, that there was no need to have the Water Tribunal, but nothing was done about it. I recall that at one stage, this Judicial Services Commission interviewed a member of the chairperson of the tribunal, but I think it recommended one person, and then the then minister requested that the matter be remitted to the Judicial Services Commission for the purpose of interviewing and recommending more than one candidate. It was then that the then chairperson was recommended for appointment. So I am acutely aware of the challenges relating to the operations of the Water Tribunal and the National Water Act in general.
I see that you also drafted the regulations regarding the procedural requirements for water use license applications and appeals,
That is
in addition to the Act itself.
That is correct.
So you are the architect of the water law, so to speak.
In part, I would lay claim to some of it.
Yes. You are at the bar right now
Yes, DCJ, I am at the bar.
since 2018.
Yes, 2018.
What kind of work do you generally do? Or maybe let me just be specific. Have you had occasion to deal with cases involving water law?
I've been fortunate enough to deal with them both before the Water Tribunal and also before we went as far as the Constitutional Court, and sadly we lost.
In which case was that?
It is the matter of the Minister of Water and Sanitation versus Lotter and others.
Oh, you were in Lotter.
I was the junior counsel there. I was intimately involved in the drafting of the papers from the High Court up until the Constitutional Court.
Okay. Do you have any experience as an adjudicator of any dispute, let alone of one involving water law?
The only instance where I was involved was when I was still at the Department of Social Development. As you might be aware that from time to time, senior managers are requested to go and chair disciplinary hearings in another government department. So I went to chair disciplinary hearing at the Department of Trade and Industry, and I've had to make a ruling. Unfortunately, I didn't attach it, but I'm not even sure whether I can still retrieve that copy. That is the extent to which I was involved in adjudicating.
That ruling is the only one you ever wrote?
That is the only one that I ever wrote.
All right. All right. Thank you very much, Advocate. I will hand over to the other commissioners to question you. Colleagues? Yes,
Good morning, Advocate.
Good morning, JP.
How are you?
I'm fine.
Good. I think I must first congratulate you on the work you did in the military judicial space. I'm a chairperson of the Court of Military Appeals, and it's a product of what you did.
No, thank you, JP.
You are acutely aware, as you say now, of the situation there. I'm more interested in what you think you will do to help the Water Tribunal dispose of its, or get rid of, or tackle its backlog that dates back a number of years.
Thank you, JP. I think firstly, I was able to find out the extent of the backlog, and I'm told it's about 200. I'm aware that there was a study by, a report that was compiled by the current chairperson, but, excuse me, the information that I get is that actually the backlog is less than what that report indicates. But generally, this is what happens. Some of the matters, although they are called backlog, are completely dormant. I'm sure some of them will predate even my time in the department. So the first thing is to find out whether or not, in fact, the party are still interested in pursuing those matters, because it may be that nobody's pursuing it, say, for the fact that it is still on the record, but something needs to be done. The second part has to do, and it's a general problem, the record. As you might be aware, the Department of Water and Sanitation stretches across the length and breadth of this country. There are 9 what they call regional offices for the Department of Water and Sanitation, and depending on the delegations in terms of the adjudication of the water use licenses, a decision could be taken, for example, in Bombela, but the appeal will have to be, when an appeal is lodged in Pretoria. So a record might be in Bombela or somewhere in the Eastern Cape or somewhere in the Northern Cape. So I think the first thing I would rather want to engage with the relevant people who are delegated the responsibility of making a decision on the issuance of water use license, to say to them, when you consider a water use license, make sure that you keep a complete record which will be ready to be dispatched to a point where it is required. But I also am aware that sometimes the record is there, but there's just a general delay, and nobody seems to care about that record being brought to the central point. And I have experienced it myself when I worked in the department. But I think the problem also has to do with the Schedule 6 of the National Water Act, and also the rules of the tribunal. You see, the rules of the tribunal, if I'm not mistaken, or the schedule, basically says the responsible authority must file a record within a reasonable period of time. What I will do is to, using my own experience of legislative drafting, firstly to relook at the rules, make sure that I make a provision to say the record must be provided within a specific period of time, and see to what extent I can align that with some aspects of Rule 53, and maybe add to that to say you need to provide a record within this period of time. If the record is not provided, the parties involved should have a recourse either where you are compelled to produce a record. If you are not producing a record, then you must decide that you are going to proceed notwithstanding the fact that the record is not there. And I'm saying so because the appeal before the Water Tribunal, it's a rehearing. So you can, if it happens that you do have a report and you don't require a record and you don't require what the minister is sitting with, then you may actually proceed even in the absence of the minister having filed the record, because what happens is that you actually go and lead evidence afresh, and the license is considered afresh, notwithstanding what the records are saying. In fact, you can even lead evidence which did not exist at the time when the license was declined. So the issue of the record is not that important if we decide that we've given you an opportunity to give us a record, you have not given us a record, we are going to proceed with the water tribunal, with the adjudication of the matter. But the one aspect also that I think needs to be looked at is the fact that, you see, sometimes people, when they lodge an appeal before the Water Tribunal, they list all possible grounds. But they don't get to a point where they say, let us sit down and agree on certain, let's have some admissions and narrow down the issues. So that when you go and appear before the Water Tribunal, we've narrowed down the issues only to a particular aspect. For example, if there are mining-related water use licenses, generally the issue is the pollution of ground or underground water. So the issue is really whether or not the issuance of a license will have a negative impact on the groundwater or surface water. And we can actually confine the whole appeal around that question because that's the only it turns on that question alone. But the general what happens is that people come there and lead evidence on any and everything without confining those matters to what actually is the issue before the water tribunal. I think that's what I think I will do. I would have to relook at the rules, okay. And I'm aware that the rules must be. It's actually the chairperson of the tribunal is empowered to develop those rules, but they must be gazetted with the approval of the minister, which is something that I do not think should be difficult to do.
Yeah. No, thank you very much. I think your first answer gives me comfort that sometimes you're told that there's a backlog, but that backlog can turn out to be a phantom. Because if you go deep and check, like we did in the labor court a number of years ago, we discovered that almost half of the files that were alleged to be pending were dormant files. And it's easy to get them out of the system. But I also like your second point, and I think what you're talking about is case management. So thank you very much, DCJ.
Any further questions, colleagues, on the virtual platform?
I just have one question. I see you are nominated by Pabasa.
That is so, Commissioner.
Thank you.
What does that have to do with anything?
Commissioner
Bennett?
Thank you. Thank you. Advocate, having regard to your career so far and the close working with the relevant government departments, I think, how can you assure the Commission that it will be fully impartial in hearing a matter where a government entity or department is involved, as a party on one of the sides?
Thank you, Commissioner. Like I think I indicated before, when I worked at especially social development and water and sanitation was the most challenging department that I've ever worked for. And you see, from time to time, I'll be required to give an opinion on whether or not this procurement should go ahead or not. And I will say, to the extent that it's unlawful, I say so. And I want to indicate one example that you may or may not be aware of. The Department of Water and Sanitation procured a license for SEP. It was, initially they thought the license was for 460 million. Then all the procurement documents were brought to me for me to vet the contract and indicate whether or not the correct supply chain process was followed. I raised a number of issues. Firstly, it turned out that other than the 450 million which was payable and approved by the Director General, there was an additional amount which did not appear on the documents brought before, or at least it seemed not to have been considered. And that the license was for 5 years. The additional amount was 76 million per year for the next 5 years. So I looked at it and I said, but the total amount of this contract is actually about $1 billion. Firstly, you are procuring something that we already have. Secondly, we have not done due diligence. Thirdly, we are procuring it even for the water boards, and some of the water boards already have this license. And I gave my opinion. They didn't like it. I thought the contract was never signed. It turned out later that, the contract was signed. Ultimately, the matter ended up in the special tribunal, and I played a role there. In fact, the SIU wanted me as a witness. I think they've been able to recover about 300 million or thereabouts. So it is not something unusual to be independent. Even here, here is much easier. In that instance, when I was at the Department of Water and Sanitation, I knew that I took a decision that someone may not like and for which I may be suspended. In fact, I used to tell my colleagues sometimes when I drove home, because I'm just giving this one example, but I would not use the same route much often. And I make sure that I don't follow, I'm not predictable in terms of the route that I took. So it would be nothing unusual for me to be independent.
Thank you. Last question. It seems if one looks at the regulations or the rules, at least, that the tribunal's hearings take place with normally 2 or more people as sitting as the tribunal. So what would the ideal, in your experience, the ideal team being, seeing that it's an interdisciplinary type of tribunal, different types of academic disciplines, as it were, involved? What would you say would be the ideal team for such a tribunal?
Thank you for the question. Firstly, it depends on the nature of the appeal. For example, some licenses are just pure irrigation. It does not require any expert. You can do it alone as a legal practitioner. But there are licenses, especially the one that involve mining. They involve quite a number of disciplines. Like in some instances, you need a hydrologist. In others, it's a geohydrologist. You also need a scientist. You may need also an environmentalist. So you need to look at firstly remember the function of the chairperson of the Water Tribunal is firstly to look at the case and see what are the issues that arise here. Depending on the nature of the case, then we can decide, okay, I think here I need, and we could, even in some instances, if it's the construction of a dam, you'll also require a civil engineer to look at the civil designs. So it depends purely on the type of the water use license. But I'm aware that the regulation, the Schedule 6 says the decision of the Water Tribunal is constituted by the majority if it is more than 2. But I am also acutely aware that if it's 2 people, it does create a problem. But I suspect it shouldn't be difficult to resolve if there's a deadlock, because once they've heard the matter, but it's only 2 people who disagree, then you can actually assign a 3rd person to look at the record, and also so that you can break the deadlock.
Thank you very much. Thank you, DCJ.
Thank you, Commissioner Barnett. Commissioner Matolo Lepu.
Thank you, DCJ. Good morning. And
Good morning, Commissioner.
You know, I'm looking at your passion and in-depth knowledge of water law, and I'm just interested in, are you interested in training some of us about this water law, which we really need that much? Especially
I'm more than willing to do it at a fee, Commissioner.
Okay.
But I do assist, like most people know that I do water law. So even if I'm not in the brief, but from time to time people call me, they ask me this and that question, so I do assist. In fact, it may well be that this is an opportune moment for me to see what I can then, for example, it may be that some of my legal colleagues who are in the legal practice are not necessarily going to be members of the tribunal, but we may as well, from time to time, invite them to come and sit and see what is going on in the Water Tribunal. But even the training is something that I will give a thought. I am acutely aware that there are very few black people in this area of law. I was just happy that I found myself in that department. And in fact, when I arrived there, I deliberately made sure, because when I arrived there, they were briefing only white people. I deliberately made sure that, in fact, I can't recall during my tenure that I had briefed a white person, because I could see that the black people were non-existent in that area of law. And that area of the exclusion, I think it was man-made.
I'm booking you for now to train practitioners.
Any further questions, colleagues? Oh, yes, DN.
No, just good morning, Advocate Loselo.
Good morning, Commissioner.
My concern is, have you had any experience in adjudication? In other words, because, listening to arguments, reading papers and taking a decision?
Well, I did indicate that my only involvement in adjudication was when I presided over a disciplinary hearing. But I must say, although I would not necessarily be adjudicating, but when you appear, especially when you run a trial, you're effectively looking at what the opponent is saying, what the witnesses have said, and you actually make your own decision through your own heads of argument that you submit. If I were to be an adjudicator and I agree with my heads of argument, that would have been the record. That would be a decision that would have made in the form of my heads of argument. But I did indicate that I only presided over one disciplinary hearing.
And your knowledge of socio-economic rights jurisprudence in South Africa?
I wouldn't claim to be an expert, but I think I have sufficient knowledge of those issues. In fact, if you were to look at the matter of Lottery, the one that went to the Constitutional Court, in part it dealt with those aspects which relate to access to water and the effect of trading in water use entitlements in relation to those who cannot afford. For example, when you look at the trading in water use entitlements, you will know that some of the licenses are more expensive than the land in respect of which that license is held. And also, I'm aware that one was a department, when we're dealing with matters of land restitution, while the land is still in the process of being returned to the rightful owner, the owner of that land disposes of the water use license at an exorbitant amount of money. When black people get that land, there's no water in that land, and they can't afford that amount of money to procure a water use license.
Thank you.
Commissioner Pillay?
Thank you, Chief Justice. Sorry, Deputy Chief Justice. It comes so naturally. Sorry, good morning, Advocate Lucelo.
Good morning, Commissioner.
I'm intrigued by your rather innovative thinking of how to get around the problem with records within the tribunal. You know, that the other parties don't get timeous records in order to proceed with the appeals. And your suggestion that because these are fresh hearings, that the matter can just be picked up from there onwards. Now, you will know that the tribunal rules are quite thin on how hearings are to proceed, how evidence is to be placed before the hearings. So as tribunal chair, unfortunately, you won't have the comfort and the certainty of rules of court the way a judge would. So I just need you to give me a very practical idea. Once you've received a notice of appeal or an application, and you're now embarking on a fresh hearing, on a re-hearing as it were, what would you do as chairperson of the tribunal?
Well, General, I think the starting point is to make sure that the record is filed, because in some instances where the record is not there, you are unable to supplement your grounds of appeal. But assuming that you ultimately get the record in time and the parties have been able, the applicant has been able to supplement his or her grounds of appeal, and the respondent has been able to respond thereto, the next step is to set the matter down. But I think what I would want to do, like I indicate, is that I would rather ask the parties to narrow down, like to hold like a pre-trial conference of sort, to narrow down the issues, to avoid a situation where you go there and the appeal is on a number of grounds which are actually relevant for the purpose of determining the appeal. So I would rather go that route of asking the parties to narrow down the issues, and I will try and satisfy myself that in fact the issues have been narrowed down to the extent permissible. And from there I'll set the matter down. Because if you've narrowed down the issues, in some instances you would realize that, well, it could take you just half a day to deal with all those issues. But if you leave it open-ended, like in one matter where I was involved, then it takes days to finalize it. But you can see that the dispute is only around one issue, but there are other issues which are involved. I'm not sure whether I answered your question.
I think it's the beginning of an answer,
Okay.
and I'm really focusing now on the case management process.
Okay.
What role do you see for yourself as tribunal chair in the case management process? And how is it, I mean, it's one thing to say that you ask the parties to narrow down the issues, but how do you as tribunal chair direct that process of
Okay,
narrowing
first-
down the issues?
okay.
Particularly, can I just finish the question?
Okay.
Particularly in the context of the water tribunal, where what you will see is that there is huge scope for expert evidence because of the scientific and technological issues that may arise. And particularly where there is evidence, expert evidence involved. What role do you see yourself as tribunal chair playing in ensuring that that expert evidence goes through the process of being ready to be dealt with at a trial?
Okay, no, thanks for the question. Okay, firstly, let me say, remember, as a chairperson, I would assign some of this matter to some members, but let us assume that it is me sitting, and I think that will be the understanding that we will have to do it. Insofar as there are expert evidences, I would then want the experts to meet and to draft their own minutes so that we see the areas on which they agree and the ones that they disagree. In that case, and sometimes, at least I'll use my experience in the Gauteng division, that you may actually call for a judicial case management of sorts where you as the chairperson, you sit there and you go through and then you assist in trying to thresh out those issues, and to an extent that the minutes are required, joint minutes of the experts are required, you make sure that they are made available, and only then that the matter can then be set down, because it will be now trial ready, and you can decide on the number of witnesses that you require, and to an extent that the joint minutes suggest that there's an area of disagreement that will require the leading of oral evidence.
And my last question, you find usually that in these case management meetings, parties make all sorts of undertakings, particularly in relation to timelines. What happens if a party doesn't meet the timelines?
Well, I think you can always compel them to make a decision to comply with the timelines that you have provided. I can't think of a situation where I can't ignore the fact that they have not met the timeline, but I can make sure that they are compelled to comply with the timeline. And I can do that maybe through, as part of the rejigging of the rules of the tribunal.
Thank you, DCJ.
Thank you, DCJ. Good morning, Advocate Lucille.
Good morning, Commissioner.
This is just a follow-up on the line of questions put to you by Commissioner Pillay. Would what you have just told us not perhaps necessitate that you revisit the rules and regulation just to ensure whether there is a regulatory framework dealing exactly with that, and possible, borrow from the rules of, from the uniform rules, so that even the parties themselves know where exactly they stand in terms of the regulatory framework?
No, I did indicate earlier that the first thing that I would have to look at are the rules of the tribunal, and that to the extent permissible, we will have to look at the uniform rules and copy some aspects of the uniform rules, and also even from the special tribunal, because they also have their own rules, and see how we can mesh all of them and at least assist in a speedier resolution of disputes before the water tribunal.
Thank you. Thank you, DCJ.
No further questions then, colleagues? This brings us to the close of your interview, Counsel. Thank you for making yourself available for this position. I wish you all the best. You're excused.
Thank you, DCJ.
is it still morning? Good morning, Mr. Nkele.
Morning, DCJ.
How are you?
I'm good, thank you. And how are you?
I'm fine, thanks. It's good to see you after so many, many years. You're still a young man. I think you were doing articles when I last saw you.
Thank you, that was then. Thank
Yeah,
you.
well, that is by way of a disclosure that I know the candidate colleagues. You are an attorney of 21 years.
Actually, 25 DCJ.
Is it 25?
Having been admitted on the 4th of June, 1998. 22 years running my own practice.
You had obtained a BProc degree and an LLB from the then University of Transkei before you started practicing, of course.
I started my articles with a BProc degree and at the same time did my LLB. Then I got admitted in 98 and graduated my LLB at the same time. In fact, 98 was a year of great achievements.
You obtained your articles and your postgrad degree.
Yes, DCJ.
All right. Can you tell us, let me verify if you are a South African citizen. The Act requires that
Yes,
an
DCJ.
incumbent of this position be a South African citizen.
Xhosa speaking, yes.
All right. Well, you could speak closer, being
I
a
speak it
Zimbabwean. So. All right. What kind of work do you do generally in that practice of yours?
I started off doing general litigation, MVA and medical negligence, having inherited a practice from my principal, Mr. Musu. Then I felt that I needed to specialize, and I became interested in mediation and arbitration. That's the work that I do. I do general civil, I do motor vehicle accident claims, medical negligence, I do mediations and arbitrations, as well as adjudications. I also chair disciplinary hearings. I'm being called now and then to help in that regard.
Okay, we'll get there. I see that you have a large collection of academic certificates, which include one as a fellow of the Association of Arbitrators.
Yes, DCJ.
And the other one is on mediation.
With the legal education and development.
Yes. And you also did an evictions and landlords tenant disputes course.
Yes, DCJ.
You actually have 2 certificates in arbitration. Is that so?
The other one is with the Arbitration Foundation of South Africa. Yes, DCJ.
One is for arbitration in the construction industry.
Yes, they provide a specialist course in construction.
And you also have one in alternative dispute resolution.
Yes, it's a certificate that is provided by AFSA in conjunction with the University of Pretoria.
All right. And so that was in aid of this work you say you do in arbitration and dispute resolution.
Yes, DCJ.
Are you a member, or have you been a member of an administrative tribunal by any chance?
I'm a past member of a chairperson, in fact, of a body appointed by the Department of Labor to chair dispute arising from injuries on duty under the COIDA Act. I
I chaired those disputes, we prepared the rulings. I'm also chairing disputes for a university in the Eastern Cape, student disciplinary hearings and appeals. I'm also currently a chairperson of the municipal board for another municipality in the Eastern Cape, where we investigate disputes and complaints arise of financial irregularities.
All right.
I am also, of course, getting instructions now and then from the Association of Arbitrators to deal with the arbitrations, adjudications that at times even involve departments. That's my experience in that regard.
All right.
TCG, thank you.
So I imagine that you get to write rulings in all these capacities.
Yes, TCG.
Did you attach any of those rulings to your application?
Because I was not aware that they are needed, I didn't.
You didn't?
I didn't.
All right. How many would you say you have written on estimate?
There are more than 10, I can say, and there's quite an interesting one that really stands out, I believe, that which involved a municipality and a service provider. Was a dispute about payment and the kind of work that has been done. It involved a lot of experts that provided reports, your geologists, your architects, your quantity surveyors. That one was quite interesting, and it was an eye-opener, if I can mention that in particular. Thank you.
All right. Do you have any experience in the area of water law?
I've got experience in litigation. I'm on the panel of one municipality to defend cases of that nature. And I also...
Relating to water law?
Relating to water law. Mm-hmm. And I also, from that experience, I decided to sue another municipality for the provision of water in my area, where I come from, Ngobo. So there's a lot of litigation around that and other, for the provision of toilets against the relevant departments as well. Mm-hmm. So that's the experience that I have, and it became very interesting. That's the exposure that I can mention. TCG, thank you.
All right. Well, I take it you would be familiar with the National Water Act in that case?
Yes, there is familiarity.
Okay. Can you tell us what the purpose of the Water Tribunal is and what its functions are?
The main purpose that can come to mind is to protect, develop, and conserve the scarce water resources. That's the main purpose that I could discern from a reading of Section 2 of that Act. Mm-hmm. I think because of that purpose, it was felt necessary to establish a tribunal to ensure that there is compliance by everybody regarding the use of water, the issue of licenses, and everything that the Act requires. So that's my understanding of the purpose of the Act.
Mm. What do you understand the role of the chairperson of the tribunal to be?
Other than facilitating quick resolution of disputes, applications and appeals that get lodged with the dispute, is to ensure that the tribunal functions optimally, quickly, to resolve those disputes, and to ensure that the tribunal is well known. Because in my area, I don't think there's anybody who knows anything about what the tribunal does to ensure that the disputes are dealt with as quickly as possible. That's my perception of the role of the chairperson.
Can you tell us if a decision of the tribunal can be taken on appeal?
In terms of the rules, DCJ, it can be taken on appeal only on a question of law.
And to which forum does that appeal go?
To the High Court, DCJ.
All right, thank you, Mr. Nkele. I'm going to hand over to the other commissioners to question you.
Thank you, DCJ.
Any questions for this candidate, colleagues? Yes, DM?
Good afternoon. No, it's still morning. Good morning, Mr. Nkele.
Morning, Deputy Minister.
What's your understanding of the current problems that the Water Tribunal is facing?
From the information that I could gather out of the research that I conducted is that, one, there is a backlog. Two, as I said, there is no much publicity of the work that the tribunal does, especially in the areas that I come from. I come from the Eastern Cape. So much needs to be done to conduct awareness campaigns. I've got in mind the emerging farmers that operate in these areas. I don't think they know that they need to apply for water licenses, and if so, where, how? I don't think they know that they need to get permissions for the drilling of boreholes, but they need water for what they set out to do. That's my understanding of the stark challenges of the tribunal in a nutshell, Deputy Minister.
Thanks. Are you aware of a diagnostic report from the former chair?
I haven't been able to place my hand on that report. I've tried, but I couldn't get it.
How did you try to saying it came up earlier?
I tried the website, but I couldn't get through.
And you didn't think of emailing the registrar?
No, not at all.
Oh, okay. But how would you address the backlog problem?
My experience as an arbitrator is that will come in handy. That's the first thing. If I get appointed, the first task is to get a bird's eye view of the extent of the backlog at the tribunal. Then get down to know which matters are still active, so that the parties involved in those matters that are still active are conducted with a view to ensure that some kind of case management is conducted, which will then lead to a timeline about what needs to be done when, for purposes of ensuring that there is progress towards hearing and finalization of the matters at the tribunal. So, to steal an idea into what is done at the High Court and what is done by arbitrators who are assigned cases would definitely help to deal expeditiously with the progress, with the backlog that is at the tribunal. I understand that, Deputy Minister, that would involve the amendment of the rules. I've got in mind in particular the aspect of mediation, to get parties to sit together and settle their dispute, agree on terms of settlement, and then make an order, and make that an order of the tribunal. In that regard, Section 150 gives only the minister the prerogative to allow the parties to get into mediation. So mediation is one of the ways in which I think would help to deal with the backlog, because parties will get to settle their matters on their own. But I think that role needs to be shifted to the chairperson or to the tribunal or to any other member who presides over a case. That would definitely need the buy-in of the minister, amendment of the rules, but that needs to be attended to, in my view. That's the long and short of my approach to deal with the backlog.
Okay, thanks very much.
Can I just follow up on one aspect, Deputy Chief Justice? Mr. Ngele, I'm very impressed with what you've been able to do with your qualifications, as it appears from your CV. But I think my anxiety is whether you are fit for this job. The candidate that came before you did get hold of the diagnostic report. He knows that there are 200 cases, and he knows that out of those, about 60 are dormant, and there are probably only 140 that are active. So when you respond to the minister and say, well, I'm sorry I couldn't get my hands onto the diagnostic report, I'm just not sure whether you tried hard enough to know the problem, because you're not an obvious specialist in the area, and since you've got that deficiency, I would have expected that you would try to get to grips with the problem. So can you just respond to that?
Thank you, Commissioner. That I must concede, I was not aware that I needed to contact the people that deal with. So being afraid to deal with the people inside when I know that I've been shortlisted, I think that was what main reason. I didn't want to get anybody compromised, in particular because I may disclose that Mr. Koba was my article clerk, the registrar. So I didn't want to compromise him in any way.
Yes. Then the other thing I just want to know, because one of the things we should be evaluating is your knowledge of the substantive area of water law. There is a case that was at the Constitutional Court in March, which involved Section 25 of the Water Act, decided unanimously. What was that case about, and what was the outcome?
My memory serves me well, it's a case of Lotta versus Minister.
Yes, that's the case. I just want to know, in essence, what was the dispute and what did the unanimous court find?
The dispute was about whether or not the water rights and license could be transferred, and that there could be payment for those rights, and that was confirmed by the Constitutional Court, if I understand the ratio of the case.
Yes, there were two other issues, but you are not the only one who didn't get the other two issues, but I think let's stick to the Section 25 one issue, unless you want to expand.
No.
All right, thank you.
Thanks, Commissioner.
Any further questions, colleagues on the virtual platform?
Thank you, DCJ. I have a question.
Yes,
Good
carry
day,
on,
Mr.
Commissioner
Nkele.
Bennett.
Thank you. Mr. Nkele, a witness appearing before a tribunal refuses to answer a question. The Water Tribunal now refuses to answer a question, and I'm not talking about a question where privilege might affect it, so it's a question that should be answered. It's important for the tribunal to hear the answer. He refuses. What can the tribunal do, and how should the chairperson deal with such a situation?
Thank you. Anybody who appears before a tribunal would have been subpoenaed. So if he or she fails to answer a question, that will be contempt of the tribunal. And contempt will have to be referred to the High Court.
Thank you. And then if you were conducting a tribunal hearing, what would be an ideal team to conduct such a hearing, bearing in mind that there are various disciplines that could be involved?
Yes, various people are appointed as members of the tribunal according to their qualifications. So the most appropriately qualified people for that particular kind of dispute should deal with that dispute. That will be my approach.
Thank you very much. Thank you, DCJ.
Thank you, Commissioner Barnett. Any further questions, colleagues? All right.
Thank you, DCJ. Good morning, Mr. Nkele.
Morning, ADP.
I must also disclose that I've known you for plus minus 25 years. I've got one question for you.
Thank you.
Would your rulings in the labor-related disputes that you chaired entail the provision of comprehensive reasons in support of those rulings?
Thank you, ADP. Indeed, especially in the construction dispute that I normally conduct, you are required to state your reasons. You are required to make sure that you elaborate on your findings. So that experience, ADP, I believe, will come in handy if I get appointed as a chair, and will help me, and I won't experience any problem.
Would that be in the same way that a judicial officer would furnish reasons for the orders that they make?
Definitely, ADP.
Thank you. Thank
you.
you, DCJ.
Thank you, AP. No further questions then, colleagues? Mr. Nkele, this brings us to the end of your interview.
Thank you. I'm grateful for the
Thank
opportunity.
you for joining us
Thank
this
you.
morning. You're excused.
Thank you.
Good morning, Advocate Velgemoot.
That's correct, my lady.
Okay.
Good morning, Deputy Chief Justice.
How are you?
I'm very well, thank you. Thank you for the opportunity to be here.
Good. Are you a sort
Sound,
of...
please, DCJ.
Sorry? Did I hear a voice?
Yes, there was no sound, but they've switched it on now, DCJ. Thank you.
Is it fine now?
It's fine now. Thank you very much.
Okay. Are you a South African citizen?
Very proudly so.
Yeah. What academic qualifications do you have?
Deputy Chief Justice, I studied at the University of Stellenbosch, where I obtained the degree BA Law, coupled with a degree in economics and Latin. I subsequently did an honours degree in African languages. I also obtained the LLB degree from the University of Stellenbosch. Thereafter, I completed my pupillage at the Cape Bar and was fortunate to be granted the opportunity to study at the University of Aberdeen in Scotland, where I did a master's degree.
In which area of the law?
That was competition law, international competition law. I subsequently obtained a LLB at the University of the Inns of Court in London and was admitted at the Bar of England and Wales, where I practiced at Keating Chambers, which is a specialist engineering and construction set. I then came to my senses and came back to South Africa, where I've been practicing from 2005 at the bar, so my seniority in practice as counsel is 23 years.
All right. What experience do you have that would qualify you for this job you've applied?
Deputy Chief Justice, I've done in my 23 years of litigation, from the highest to the lowest levels, from the Magistrates Court all the way to the House of Lords, and currently in the International Commercial Court, where I've done a number of very, very large cases. I'm a specialist in engineering and technology law, which always, in some way, shape, or form, touches water and aspects of water. I've been involved in the junior counsel in the Shell matter on the East Coast. I've been involved in the City of Cape Town desalination water plant dispute. I've advised on several aspects of water law, water purification specifically, desalination specifically. So my range of experience with water and coupled in the mining as well as the construction milieu had been extensive.
I see that you've acted as a judge.
Indeed, I've
You don't mention that important factor.
my apologies for that, Deputy Chief Justice. I was granted that privilege by Deputy Judge Sutherland last year, and I've had my stint at acting as a judge. I'm also frequently appointed to act as arbitrator and adjudicator in matters, both in South Africa as well as internationally.
Yeah. How long did you act as a judge?
I only did a week. I was allocated 1 week, and I managed to finish my case. I believe the judgment had been reported or will be reported at SAFLI. It was the matter of Slela and others versus the New Presbyterian Church. So I believe the judgment will be reported soon.
So you wrote a judgment only in that one case?
That's correct, as an acting judge. As an arbitrator and as an adjudicator, I've dealt with more matters than I care to remember.
And wrote rulings, of course?
Indeed, indeed.
All right.
Most of those matters, especially in the construction milieu, are typically very complex in law, very heavy in paper. I'm currently in a matter in the International Commercial Court with 35,704 pages. So I am well versed in reducing complex facts and disputes into eligible judgment.
One of the law bodies which commented on the suitability of all the candidates for this position remarked that your experience seems to be internationally based, and they doubt that, how do they put it? They say South Africa needs someone who's more well-versed with our uniqueness as a country of mostly have-nots, and someone who understands these issues, who it seems in their view would not be you. What would you say to that comment?
Deputy Chief, with the greatest respect to that comment, it is misguided. My feet are very firmly on the ground in South Africa. The fact that I qualified overseas gives me the opportunity to tap into what is currently seen as best arbitration and adjudication practice. But I'm a South African born and bred. I came to this country because I love it, and I live in this country. I am involved in various community aspects and issues. I provide pro bono legal services where I can. During the COVID pandemic, I raised a food charity where I myself cooked for underprivileged children. I'm a South African all the way. My practice is in South Africa. The mere fact that I am privileged to appear in the international arena happens as it comes along. And I think it's merely a function of and I say this with humility, perhaps it is a question of other practitioners not having had the opportunity to appear internationally, that those matters come to me. But I would say my practice is most definitely in South Africa.
All right. What, in your view, is, well, not in your view, in the Act's, what role does the Act envisage for a chairperson of this tribunal?
In my understanding, the tribunal is in essence an appeals tribunal. It deals with decisions that have been made by the various catchment agencies, etc., etc. I view the position as chairperson, first and foremost, as a leader. It must provide leadership to the tribunal, and it must set a process which will lead to the best possible judgment. I envisage the role of the chairperson to be that of a judge, taking hold of the matter, so to speak, from the commencement, liaising with parties to get the most effective procedure in place with timelines. I know that there is a very, very big backlog at the moment. There's only one way to eradicate a backlog like that, and that is through very hard work and proper management. So I see the role of the chairperson to get hold of the matter and the parties, arrange timetables for the exchanging of pleadings. If the matter requires experts, that experts be appointed and expert reports exchanged to narrow down issues, deal with the presentation of evidence at the tribunal, and then expeditiously as possible thereafter obviously provide judgment. I believe, in my experience in water matters, it is frequently required that the chairperson be assisted by other professionals, such as engineers or chemical experts. And I think there is I think it is also the role of the chairman to identify where there is a need for experts, and let those experts do their thing and come up with a joint report, if at all possible.
Thank you, Council. Questions, Commissioners?
Thank you, Deputy Chief.
Prof?
Thank you very much, DCJ. Good morning, Advocate.
Good morning. Is my eyesight correct? Is it Professor?
Yes, it is.
Good morning, Professor.
I just want to ask you one question. By now we know that there is an issue in relation to the backlog that is already being experienced. Of course, there are different dimensions to that. I just want to know, apart from the backlogs, what are other challenges that perhaps that particular body is experiencing. And I'm asking in relation to where it is situated and the fact that it deals with issues that cover across South Africa. And in most instances, in the most remote of areas where the issues relating to water and licensing are actually located. I'm asking that question in that context. What are the challenges in that regard?
I'm going to deal with the second part of your question first, Professor. I think, in my opinion, the fact that the tribunal is mobile is actually a very big positive, because you can go to where the problem is, and it's very often, let's say in a rural area where people just don't have access or can afford transport and experts, etc., etc., etc. So I think the fact that the body is mobile is a plus, and it can certainly assist. It's much easier for a chairman and members to go to a town hall in a small town and conduct a hearing than it is for those people to come to Johannesburg and with the coupled expenses. So that's the second part of the question. Dealing with the first part, to deal with a backlog on a court roll is a question of management. It's a simple question of allocating resources and doing the work. And with proper management, I've seen, with respect to the Deputy Chief Justice, I've seen that with proper management of a case, often cases disappear because the parties realize that the issues disappear. And secondly, with proper management of a case, you can determine strict timelines with the cooperation of the parties, so that by the time the matter comes to court, it's a quick case. So with hard work and proper management and proper planning, a backlog is not a big problem. Obviously easier said than done, but I mean, well, we all know that there's backlogs in courts all over the world, and it's a big problem, and it's a problem that is very close, very dear to me, because justice postponed is justice denied.
Thank you very much. Thank you, DCJ.
Thank you, Professor.
Yes, Deputy Minister.
Thanks. Good morning, Advocate Valkamut. Mine question is really, obviously with issues before the Water Tribunal, some of those issues would be relating to issues of access to water. And there are a number of socio-economic rights issues which would come up. In the list that you've given from page 4, the list of notable matters, I don't see any really dealing with socio-economic rights. I see there's one of international fishing quotas and fishing rights, small-scale fisher people's rights would be socio-economic, but you're talking about international fishing quotas, so I suspect that your client was probably more from that sector. But have you had any experience of socio-economic rights, jurisprudence, socio-economic disputes involving socio-economic rights?
Very much.
Can you give more detail of that?
Just to return to the first question about the fishing rights, in that matter I was actually representing the entire tuna fleet with the allocation of international fishing quotas. And you will remember that there was a line fishing matter where the line fishing rights had just been removed by the minister, and unlawfully so. In that matter, I acted pro deo on behalf of all the line fishermen from Cape Town all the way up to East London. I provide pro deo services to fishermen on a standing basis. So we work with the late Wally Kroom, who is the chairman of the line fishing industry. So I'm very much with my feet on the ground. And so far as social justice goes, you would be familiar with the Shell matter, where Shell wanted to do fracking on the East Coast. Now, in that matter, I represented the local community of the Pondo tribe, to which that stretch of water is holy land for them. So I do a lot of work with local social justice, and you'll be surprised that in the construction industry you work with people and you work with labourers and you work with those. So the rights of those people and their rights to employment and fair treatment, etc., often lies at the very, very bottom of these highfalutin international matters. So currently, I've been instructed by a firm, which I also do on a pro bono basis, to act for a group of farmers in the Transkei in the cannabis industry, which is coming up. That's a class action. So I do a lot of work with local communities and for people who can't afford the big international cases or quite frankly any case. It's like they say, the doors of the court is open. It's like the doors of the Ritz Hotel, and that is something that I am very mindful of. One of the issues that I've been sort of playing with in my head regarding legal representation, for example, of upcoming farmers. We have at the bar a compulsory 30 hours of pro amicus service that one must provide. Now, it is very easy in my position at the bar to say, or to spread it in my group and all the various groups in Sandton, as well as in Cape Town, where I do a lot of work, to say, we have a group of previously disadvantaged individuals or impecunious people who needs access to a water dispute. Please stick up your hands and make yourselves available as legal representatives. And I can assure you, advocates junior and senior will jump at the opportunity because there is that spirit at the bar.
Okay, thank you. Just one other comment. I see you are a small claims court commissioner.
I was
for Cape Town. Are you still appearing?
I had some of the most humbling experiences in the small claims court because you deal with the poorest of the poor, where a matter is sometimes legally very complex, but it's about 1,000 rand. I'm not longer involved in the small claims court. I had a very, very productive time there, and I learned a lot as an advocate as well as a presiding officer. Unfortunately, I don't, as a result of my children getting older, I can't, those court sits at night. And that was the primary reason I need to be with my family at night, which is why I no longer act in that position.
Okay, thanks very much.
Thank you, Minister.
Could I just follow up on the issue of, you call it social justice, but I think the specific question was what socio-economic rights cases, and you understand what socio-economic rights are?
I think I do.
All right, so that's the question that was being posed. It was not whether you've represented local fishermen or represented, as you call it, a Pondo tribe. It's what socio-economic rights cases have you been involved in? Can you help us with that?
If you could, sorry, I can't see who I'm addressing.
My name is Tembeka Ngcukaitobi. It doesn't matter if you can see me or not, just answer the question. What socio-economic rights cases have you been involved in?
If you could define socio-economic rights, I could answer your question.
Well, that's precisely what I started with, because you said you understand what socio-economic rights is. Because once you have a basic problem of grasping socio-economic rights, then I have a problem in appointing you, recommending you, at least for my part, to be the chairperson of a water tribunal.
Well, as a point of departure, sir, the socio-economic rights is the rights of everybody. Everybody has socio-economic rights. So
what are they?
It's a complex question. It is, as I understand it, the rights of any individual to resources, freedom, constitutional rights.
All right. Well, I'm afraid to tell you that you don't actually know what socio-economic rights are. Now, I want to also move on to another issue, because your area of specialty seems to be around construction. Is that correct?
I specialize in construction law in London, but my practice is a general commercial practice in South Africa.
All right. So you're not specializing in construction here in South Africa?
I I do have done some of the largest construction cases in South Africa.
Yes.
Amongst them, the largest oxygen production plant. I've done work on Medupi and Kusile and various other big construction matters in South Africa.
Yes. Now, one of the answers you gave, I think, to the Deputy Minister was the concern that was raised about your lack of grasp of socio-economic rights, which we now can see is evident. Is that or no, it was the Deputy Chief Justice, is that you have an international practice. And the answer, which really does worry me, is that you gave, is that it may be that it is some of the practitioners who don't have an opportunity to appear in international forums that are complaining. Did I get that correctly?
Briefing patterns at the bar is a mystery, but the fact that I have the experience to act internationally acts in my advantage. With the greatest deference to you, sir, I recently was approached by a young attorney representing a body called Lawyers for Black People, who was involved in an eviction application. I did that matter on a pro bono basis. I might not be able to answer your question about the definition of socioeconomic rights, but I can tell you that I do a lot of work for people free of charge, who's down and out, and my involvement in the community where I provide my legal services is, with respect, indisputable.
I'm not asking you that. I'm asking you if I got your answer correctly. When the point was raised that your experience is in international forums, whether it is correct that you said that the people that are complaining are people who don't have a chance to appear in those forums. Did I get that correctly or not?
No, that is not correct. That is not correct. I am not responsible as counsel for my own appointment. I get appointed by attorneys. Where they get their knowledge from, I've got no idea.
Now, just tell me, I also heard something you've said now, which also I just don't understand, that briefing patterns at the bar are a mystery. I mean, don't you understand that black advocates are systematically excluded from commercial work at the bar, and white men are preferred in commercial work? What is the mystery about that? And that is a result of apartheid and the legacy that continues.
I will not deny that with the slightest.
So then what's the mystery?
In my personal capacity, I have taken Tembelani Mayosi, Mandlakazi Mayosi, Ndabiseng Mokoena, various black counsel under my wing. Advocates for Transformation will tell you, Mr. Charles Simon, who's the Deputy Chair, Mr. Greg Papier, will tell you that I have an open door policy for all advocates, and I frequently spend many, many hours of my time to assist members of or black members of the bar.
Thank you, DCJ.
Follow up, DCJ? Oh, thank you very much. Advocate, I'm quite unsettled with some of your responses, and in one in particular, and I just want to put something to you so that I can solicit your response. If I am an attorney and I'm approached by a very poor person who wants to divorce, and I'm helping that particular client free of charge, am I dealing with a socio-economic matter under those circumstances?
I would think so.
Sure.
I would think it's first social and it's also economic.
Oh, okay. No, thank you very much.
Commissioner Pillay?
Thank you, DCJ. Good morning, Mr. Belgemot.
Good morning.
At the previous sitting of this commission, when we considered candidates for this position, I think the acting chairperson handed up a diagnostic report. Are you aware of that report?
Yes, I'm aware of it.
And you've been through the report?
I have not seen the report myself, but I've been told by a colleague of mine, we've discussed it at length, and I believe that the outstanding backlog is approximately the figures between 200 and 140 cases.
All right. I'm not interested for a second in the size of the backlog. One of the issues that Advocate Marke raised was that, firstly, the tribunal was not given its own budget, and secondly, that the budget was inadequate. Have you given any thought to the funding of the tribunal and how you would address challenges, funding challenges?
Funding is a fundamental part in the success of any body, certainly a judicial body. I think especially when experts are required for a matter, funding will have to be made available in order to get top people, to get top results. There will most certainly have to be a budget drafted by the tribunal, setting out the needs such as travel to matters, whatever the needs may be. And that budget will have to be realistic to ensure the proper functioning of the tribunal.
Can we take 2 steps back? Have you researched how the tribunal gets its funding?
The funding comes from the Department of Water, as I have it.
And beyond that, what's the process followed and how it is that you would be able to influence or ask for more funding in order to address some of the shortcomings in the working of the tribunal?
I don't know the answer to that question.
Thank you. Thank you, DCJ.
Just for completeness on the diagnostic report, you said you're aware of it, but you don't have a copy.
No.
Or you didn't get a copy. Did you try and get a copy?
No, I did not. I regret I was under extreme pressure with litigation. I have discussed the matter with another colleague of mine who is also involved in water, and I've been told by the diagnostic told of the diagnostic report. I do not have a copy in my personal possession.
Okay, but you applied. You applied when? January. So this whole time you've been under pressure. You haven't been able to try and get a copy of the report.
I'm afraid, Minister, I'm under continuous pressure all the time. But the empirical fact that there is a backlog has certainly not escaped me.
Okay.
Any questions from the virtual platform?
Yes, DCJ.
Go ahead, Commissioner.
Thank you, DCJ. Advocate Welgemoot, the matrix of legislation that relates to water disputes and water in South Africa, can you discuss that, referring to the various acts of parliament and how they interact with one another?
Well, the Water Tribunal is a function of, I believe, Section 140 of the National Water Act. And that led to the formation of the Act, and then the rules of the Act are set out as an independent body. Sorry, not the Act, as of the Tribunal is set out as an independent body.
Other legislation?
Well, water touches everything else. There'll be, I'm aware of...
Yeah, well, what other legislation is there in relation to water? The national water system?
Well, there's the licensing of water. There is the national standards regarding water. There is building standards regarding water. There is pipeline regulations. There are so many. I mean, water is an integral part of our lives and is an integral part of structure and infrastructure. And there's the laws of the sea. There is bylaws relating river pollution. There are, I think there's too many to mention, to be honest.
What's the function of the Water Research Act?
The function of research will be the research of the quality of water, the sustainability of the use of water, the monitoring of pollution in water, the avoidance thereof, the accumulation of water. That's how I have the parameters of that Act.
Okay, thank you, DCJ. Thank you, Edwin.
Thank you, Mr. Barnard.
Any more questions from the virtual platform? Okay. This is the end of your interview, Advocate Wilgemoot. Thank you very much for making yourself available for the interview. You're excused.
Thank you for the opportunity, Deputy Chief Justice, and thank you for the members of the Commission.